What am I most easily annoyed by?
I would say if people wax on about something that they have no idea what they're talking about and they're intuiting facts as they're saying them, I feel like that would be deeply upsetting to you because you're like a human Wikipedia.
Hi, besties. Welcome back to my channel. The judge has ruled, and Blake Lively must turn over her text messages with Taylor Swift. And the judge ruled that Blake Lively is the one that made Taylor Swift relevant in this case. So, after months of her crying to the media that it's Wayfair using her for clicks and views, which, by the way, the judge also addressed in his order, scolding her for constantly accusing Wayfair for using filings for publicity and calling these arguments that she's making unavailing. Yeah, unavailing. And she issued a statement following the ruling that proves she still does not understand what the judge said. So we all know that Judge Lyman has dismissed most of the case against Justin Baldoni. We are waiting for them to amend the complaint, which is due on Monday. We've learned this week that Blake's deposition is scheduled for the 23rd, which is the same day that the amended complaint is due. And in the middle of that, Blake decided she was going to file for a protective order because she doesn't want to hand over these text messages. And she claimed falsely that an anonymous insider proved that they got Taylor Swift's messages that Wayfair did. The judge also didn't buy that argument. And the judge ruled on the motion to compel by the Wayfair parties also denying that. So both denied, but the denial to Wayfair isn't as bad as you'll think. So let's get there. I'm thoroughly impressed with the response by the judge simply because it's been very exhausting for me to watch every single filing that she makes to be about Wayfair's using this for publicity. Wayfair's using this for publicity. And even responses from Taylor Swift accusing this and accusing Blake or Ryan or whoever or Justin using this for clickbait have bothered me too, because when you're in a litigation and when you're in a case and it involves what it involves, whether it's SH or the hijacking of a film or false allegations, right? If you're in a legitimate lawsuit, which I'm debatable about Blake's lawsuit being legitimate, but they're still in federal court. So to refer to a filing in court to be clickbait is really disrespectful to the justice system. It's disrespectful to the process of the court. And it sort of seems to undermine the seriousness of this case. So if you have Blake calling anything Wayfair does as clickbait, or even Taylor calling anything as clickbait, it really does undermine the seriousness of this case. So I call them both out equally for using that. But this is what the judge says. He says that the federal rules of civil procedure provide for broad discovery information for the purpose of assisting in the preparation of trial or settlement of litigated disputes. Under Federal Rule of Civil Procedure 26, parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. A court may limit discovery if the discovery sought is unreasonably, cumulative, or duplicative, irrelevant, or unduly burdensome. And he says Lively relies on the fact that Wayfair parties previously attempted to subpoena Swift, then withdrew the subpoena and made public statements that they had everything they needed. She accordingly argues that either the Wayfair parties never needed communications between Swift and Lively, in which case the Swift RFPs are irrelevant, or the Wayfair parties have already received the communications, in which case the Swift RFPs are duplicative. Each of these arguments is unavailing. Did you hear that? Did you hear that? Unavailing. The Wayfair parties have not yet received any communications between Lively and Swift. So the request to Lively is not duplicative, and the Swift RFPs are relevant. Lively herself has identified Swift as someone likely to have knowledge about complaints or discussions regarding the working environment on the set of It Ends With Us. And he cites document number 354 at 24. Lively properly notes that identification of a party in initial disclosures does not necessarily entail that all communications with the party are relevant to the claims and defenses in this case. However, the Swift RFPs are limited to communications about the film It Ends With Us or about this action. Lively alleges that Baldoni and Heath harassed her numerous ways during work on It Ends With Us, that her concerns about their behavior began early in the pre-production and production process, and that she expressed those concerns in contemporaneous messages. Given that Lively has represented that Swift had knowledge of complaints or discussions about the working environment on the film, among other issues, the requests for messages with Swift regarding the film and this action are reasonably tailored to discover information that would prove or disprove Lively's harassment and retaliation claims. I just want to respond to that. So frequently during this process, any request that Wayfair has made has been viewed as antagonistic, has been viewed as for publicity, has been viewed as nefarious, even though the judge says that Wayfair asking for her communications with Swift under these two numbers between what happened on the set and what's going on with this action, right? That's all they care about. They're not looking for 10 years of text messages, Blake. They're looking for what you told her related to this. And they're looking for that because you said she had information on it. And truthfully, it just reminds me of that meme of that girl where the implication is that she took a match and started a fire, and then she's watching the house burn down, acting like she's watching it burn down. She knows she did it with that like look on her face. You started the fire and now you're acting surprised that the house is burning down, Blake. And crying about it to the media, even after this ruling, and completely ignoring what the judge said just kind of proves to me how disconnected from reality she is. It says her motion is rooted in the broader concern that Wayfair parties are using demands for communication with Swift not to obtain information relevant to claims and defenses in court, but to prop up a public relations narrative outside of court. So the same way that Blake has been deflecting a lot of what she's done onto Justin, like the video I did yesterday. And if you haven't watched the video yesterday, please watch the video where we talked about what actually happened on the set between Blake and Justin and the threats that Ryan Reynolds allegedly made to him. You'll know that she did a lot of what she did to project and deflect her actions onto Justin so that all of her bad behavior would be viewed as what Justin did. And so that when everything came out about her, it would look like, well, he's bad too. Kind of the same way she's running this whole litigation. So, this concept that the only reason they would subpoena Taylor or even ask for communications is because they want press is such a ridiculous argument to make. Because if you file a document and if you provide initial disclosures to the opposing party and you tell them that my friend Taylor is a witness to all of this, she knows everything about all of it, all aspects. And then you say, well, they only want that because of PR. Then why did you include her on your initial disclosures? It just doesn't make sense. And I said yesterday, her argument to the court that somehow an anonymous insider leaked something also isn't going to move a judge, I didn't think. If the issue that the Wayfair parties may leak the requested communication to the press, this concern is addressed by the protective order, which he discusses how they already have this order in place. Nothing can be released. They can designate it as attorney's eyes only or confidential. And that in and of itself would bar them from leaking anything. And then he says, if the issue is rather that the fact of the request itself has been used as a part of a public relations narrative, this does not mean the request is irrelevant to the litigations or that Wayfair parties will not seek to use resulting communications in the litigation. A motion or request may be, and in this case often has been, both a legitimate litigation tactic and an attempt to maneuver in the broader court of public opinion. The mere fact that the request has been discussed in the press does not render it illegitimate. And general and somewhat hyperbolic public statements that the Wayfair parties do not need the evidence, many of which are not even attributed to the Wayfair parties, but to an anonymous insider, cannot be understood as a waiver or retraction of the RFPs, given that the Lively parties have not shown the information as irrelevant or its production would be unduly burdensome. The claim that the Wayfair parties have dramatized the request to the press does not justify a protective order against the production of responsive documents. Her motion for a protective order is denied. If I can reiterate anything, what he just said there was a very big scolding to her. Judges don't generally use language that is disrespectful. They don't discuss or shame people. But if someone is continually bringing issues to the court and using the same argument over and over and over again, like Blake has, where any single time they file something, they're claiming it is being used for public relations. What he's telling her there is this argument that you continue to make to me does not change the fact that there are legitimate issues in this lawsuit that you have raised and Wayfair has raised that, regardless if you believe it's only being done for press, doesn't change the fact of what is required of you as a plaintiff or a cross defendant. She's not yet, but she might be on Monday, and your responsibilities of discovery. Just because someone is a celebrity and you have a celebrity friend doesn't change the fact that you told Wayfair and this court that she was a relevant witness. And then after you've told us that she's a relevant witness, you're then accusing them of using this for press, even though you're the one that told them this. And just because it's used or discussed in the press doesn't make the need for the communications any less valid. In a way, he's telling her that you need to stop acting like everything that's happening in this court is not legitimate. You need to stop acting in this court like legitimate filings and legitimate responses and asks by your opposing party for records, which under the rules of discovery you are obligated to give. Stop acting like you're the victim, really, of some PR smear campaign. That's how it sounds to me. The mere fact the request has been discussed in the press does not render it illegitimate. And a general and hyperbolic public statement, hyperbolic means an exaggerated statement. So what he's saying is her claim that some random insider said that they got what they needed and more is just exaggerations and maybe a little bit dramatic, but it doesn't change the fact that she can't even link it to anyone. And so for her to come into this court and try to say that this insider is proof that they're liars doesn't matter because it doesn't waive their demand. So they're not saying, okay, we're going to not ask you for these. They never waived it. She was trying to use that as a waiver. And it also doesn't prove that it's irrelevant. So I was impressed with that. Now, obviously, Blake Lively doesn't like to understand or really read because immediately after the ruling was released, she ran to the press and issued a statement. She did. After yesterday, where she was demanding all of the reporters and to name all of the reporters they talked to, Wayfair, she ran to TMZ and gave them a statement, and to People, and to every outlet. And you know who didn't give a comment? Justin Baldoni. You know how little they have been commenting as of late? It's been very minimal. And instead of focusing on what they got right in the court, they focus on the fact that the judge denied the motion to compel by Wayfair. So yes, the judge did deny Wayfair's motion to compel, but his reasons for denying it were not because they're using this for press or that, Wayfair didn't have an argument. It was that Blake's lawyers told the court, well, she has already said she will provide these documents. She's not fighting giving it. And because Wayfair also hasn't provided everything that Blake has given, they don't get to get things earlier than what they need, than the July 1st mid deadline for discovery. You can only seek a motion to compel if they're saying they're not going to provide this information. That's really what he said. Because he says Lively states that she has agreed to produce the documents except the communications with Swift, and this is on track for substantial completion by July 1st. She has proposed the Wayfair parties that she will produce all documents in the requested categories by the end of this week if they produce what she wants. And there's no reason the court can order Lively to expedite production when they have also refused to do so. So that was what they said about the motion to compel. So her response, her rep's response, the court outright denied the Wayfair party's motion to compel documents from Miss Lively, who has produced far more documents in this case than the Wayfair parties combined. Okay, so again, all of the documents that she has provided has been from the subpoena from Van Zandt Inc., right? That she illegally got access to Jen Abel's phone. Further, the court's protective order ruling rests on the Wayfair party's admission that they received nothing from Taylor Swift, which is exactly the opposite of what their insider claimed 2 weeks ago. Did you see what they did there? They're trying to again attribute their insider to who? The attorneys who literally the judge said, and general and somewhat hyperbolic public statement that the Wayfair parties do not need the evidence, many of which are not even attributed to the Wayfair parties, but to an anonymous insider, cannot be understood as a waiver or retraction. So she's twisting it. He never said that anonymous insider was any one of the Wayfair parties. But she's like, it's resting on the fact that they said they got everything they needed. So she's trying to say they lied. He's saying, well, even if it was, it's only an exaggeration. And it says, as for the rest, Justin Baldoni and the Wayfair parties demanded access to Taylor Swift's private communications, despite having already subpoenaed and then withdrawn that subpoena. And the judge also addressed that, which said just because they withdrew it from Taylor doesn't mean that she doesn't have to turn it over. So all of this is just, again, PR spin. And it says, we will continue to call out Baldoni's relentless efforts to exploit Miss Swift's popularity, which from day one has been nothing more than a distraction from the serious sexual harassment and retaliation accusations he and the Wayfair parties are facing. She's telling the court, and this statement is attributed to her rep. This is an out-of-court statement thumbing the nose at the judge's ruling. The judge told her that they are not being exploitative of Taylor Swift and that Miss Lively is the one that actually made Taylor Swift relevant. And no one is exploiting Taylor Swift by Lively telling them, yes, she has relevant information. It's Lively that's exploiting Swift. Given that Lively has represented that Swift has knowledge of complaints or discussions about the working environment on the film, among other issues, the requests for the messages with Swift regarding the film and this action are reasonably tailored to discover information that would prove or disprove her claims of harassment and retaliation. They are relevant. You can't exploit something that is relevant. If I were Wayfair, I would start documenting all of her out-of-court statements that are attributed to a rep, not her legal team, and just keep track of everything that she's saying. When you start twisting what the judge says to the court of public opinion and you think that people are stupid, judges are not keen to that. And she issued this statement basically after a judge reprimanded her for doing this and telling her that it doesn't matter if she thinks it's being used for PR. It says, this concern does not justify denying the Wayfair party's relevant discovery. So her belief that Wayfair is exploiting this for publicity does not justify denying the Wayfair party's relevant and their right to relevant discovery. She truly thinks that she can spin anything, and we're stupid. And certainly, I'm sure that Taylor Swift doesn't want to be dragged into the middle of this. And we obviously have no clue what the agreement was between Venable and between Wayfair about why they agreed to drop the subpoena. We can only go based off of nameless sources that are telling Daily Mail or other outlets that it was Scott Swift that handed over information. But even then, we still don't know if that's true. We really don't. And as far as Wayfair has represented to the court, they didn't get any communications between Swift and Lively whatsoever. No texts, nothing. Did they get information that Scott had with Taylor's lawyers? That I don't know. But truthfully, anyone suggesting that Taylor Swift is being exploited because of this is acting like a toddler. And even Taylor Swift's own team being flippant and acting like she's only being used for clickbait and how she had no involvement in this and using that statement to say, I didn't do anything on the set. I had nothing to do with the casting. I had nothing to do with the editing. I had nothing to do with any of this. When the truth is, Baldoni has said that she was at the penthouse. And according to Baldoni, at the penthouse, Taylor was praising the script changes. Now, was she doing that just to support a friend? Maybe. But this concept that she wasn't there, she might not have been. And I'm confident that Blake overrepresented what she did. I'm confident that Blake lied to people because I know she lied to people. She literally told cast members that Taylor would let them go to football games. That's how she wooed them and got them onto her side. She made all kinds of promises about access to Taylor Swift, to cast members, to crew, to get them to, team up against her against Baldoni. You can be on my team with my dragons. She used the same tactics on the cast as she did with Baldoni. And so when Taylor, and I criticized them when they made the statement, when she said that there's no involvement, okay, so if there's no involvement, just prove it. You can't use PR to get out of a legal case. It doesn't work that way. Once a lawsuit is filed, if your name is mentioned, no matter how much you stomp your feet up and down and say, I wasn't involved and this is all clickbait, doesn't change the requirements of the court and the exposure that you have to possible discovery as well as being a witness. And if Blake hands over documents from between her and Taylor that show that she said things that were the opposite about Baldoni, or if she didn't make statements about the conditions on the set, or if she did use Taylor Swift, or if she did scheme with Taylor Swift, that will come out. My position has always been, when it comes to Taylor, is don't say anything at all. And when a PR agency is dictating the position you take, and you think because of your power that you can stomp your feet and say, I wasn't involved, I wasn't involved, I wasn't involved, I wasn't involved, doesn't change the fact that Blake says you were. And we know that you were at least there at the rooftops when it came to like the discussion at the penthouse. And even if you think that Blake ambushed you, you represented to TMZ that you just said hi to him. You didn't say anything about the script. And yet Baldoni says you did. So who's lying? I don't think that Taylor was part of this as some sort of mastermind. I think Blake absolutely exploited her. But I hope this wakes up Taylor's side and makes them realize that using terms like clickbait to discuss actual legitimate legal claims not only diminishes the lawsuit again Blake has filed, but it diminishes what Baldoni went through. And furthermore, while Blake may have used Taylor, and while Blake may have exploited Taylor, what bothers me about Taylor's PR, and I'll say this, is that she's never wrong, ever. Anytime something happens where there's negative publicity that could impact her, she is always the victim. Always. Katy Perry, victim. Her masters, the victim. Anytime something happens with a friend, she's the victim of the friend. She's always painted as the victim. And you cannot always be the victim. You can't be friends with someone like Blake for 10 plus years and act like you barely knew her. Remember when we were talking about the article where Taylor was trying to say, like, I barely knew her. We didn't have that kind of relationship where we supported each other. Well, then why, Taylor, did she dedicate songs to Blake's kids and names of songs on an album to Blake's kids? And why did she, shout them out at concerts? To act like you were only friends with her because she was rich is ridiculous, because you clearly had other connections to this woman. That was far deeper than just we hung out sometimes and I liked her because she was rich. And I would never have supported her. If you never would have supported her, why are songs dedicated to her kids? That doesn't even make sense. It's like just trying to distance herself from what's happening here. You don't hang around with people like Blake and Ryan and not know who they are. Blake and Ryan have shown themselves to people. Everyone I talk to from behind the scenes knows exactly who Blake and Ryan are. And they're not hiding that from Taylor. And they're not hiding that from their friends. The friends might not want to speak out about it because they might have fear of Blake and Ryan. And that's true. Maybe Taylor did have fear of them. But at the same time, to try to act like you don't know them and you weren't associated with them now that they are facing backlash isn't accountability or a good look. The more responsible thing, in my opinion, would be for her PR to just keep quiet, cooperate if they need to cooperate, provide what they need to provide. And if you weren't involved, allow it to get through the court and prove it. No different than what Justin has to do with trying to disprove what Blake says against him. If you weren't involved and Blake lied about you the same way that she lied about Baldoni, which I believe is what happened here. I don't believe that Taylor was involved here, as Blake has said, then allow it to go through court. That's it. And be respectful of the judicial process, both Blake and Taylor. So what are your thoughts about this? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thank you so much for watching. Bye, guys.